Good afternoon and welcome. My name is Banaz Mansouri. I'm a senior attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We are the only freestanding legal aid office in the country solely dedicated to unemployment issues. The Unemployment Law Project provides low-cost representation and free advice and counsel to people in Washington state who have been denied unemployment benefits or whose benefit award is being challenged. We're here today with our weekly webinar, which occurs each Monday at noon. The purpose of today's webinar is to share the latest news on unemployment benefits, to provide information about our ongoing lawsuit, and to answer your questions. We'll share commonly asked questions throughout the webinar, and then you can enter your questions in our Q&A chat box, and we'll aim to answer them live. I'd like to introduce our speakers from the Unemployment Law Project, Executive Director John Tierpak, and Staff Attorney and Policy Director Ann Paxton. I'll now turn it over to you, Ann.
Thank you, Banaz, and good afternoon. Welcome to our weekly webinar. Very nice to see everyone turn out for this. We have a lot of topics to cover every week, and this week the big topic, of course, is Lost Wages Assistance Program. So I'll start out with that. As most people know, on August 8th, the President signed a memorandum, kind of passing as an executive order, but basically a memorandum that would order the Disaster Relief Fund to provide funding to the states to add an extra $300 to $400 to unemployment benefits that are being distributed to people with COVID-related reasons for being unemployed or partially employed. So what happened with that is several states have applied for permission to participate in that program, and Washington is one of them. So we applied about a week ago and received approval on last Monday. And the program is gearing up to start, not quite clear when, because it's going to take a while for the IT system to get up to speed on distributing the funds. So what it involves is we have approval to distribute 3 weeks, exactly 3 weeks right now, of $300 extra per week, similar to what the PUC $600 was, although obviously half as much. And also it's only for 3 weeks that people would have had to have filed claims for. That is between July 26th and August 15th. Now it's possible that that could be extended. There is $44 billion in the Disaster Relief Fund that is at this moment available for the states to distribute that. And Washington right now will be distributing about 400 million of that with just the 3 weeks. But it could turn out that the money is drawn down because it is FEMA money that is supposed to be dedicated for disasters. And as we all know, there's several of those happening right now. And as hurricane season hasn't really hit its peak yet, and wildfire season hasn't either, chances are good that there may be some more money drawn down and less available. Technically, it would be available till December 27th, but it doesn't look likely that that's going to happen. The claims would be retroactive to whenever you filed within that period, July 26th through August 15th. If you are a PUA recipient, you would qualify automatically. But people who are receiving regular benefits have to answer questions on a questionnaire to show that this is different from the PUC program. Well, you need to show that your unemployment is due to COVID-related reasons, similar to what happens with PUA. So you can get it if you have regular benefits, but you have to have a PUA. You have to have a COVID-related reason for being unemployed. So that will be a questionnaire that has to be answered. As I mentioned, it will be a few weeks before the benefits are sent in most cases. Apparently 2 states, Arizona and Texas, say they have already issued some payments. And a few other states say they will have them running up this week. Trump has said that the order would approve $400 in benefits. That is, if the state kicks in an extra $100. So most states have said they don't have the money to contribute that extra $100. Only 3 states have said they will add it, and that's Kentucky, Montana, and West Virginia that would be distributing $400. And Washington is not doing this, but before you feel that we're kind of letting our state down, you should realize that in Kentucky, Montana, and West Virginia, their maximum benefit is about $300 or $400 less than our maximum benefit in Washington. So it's actually closer to the average in Washington, which is $470. So they're making up, they have a lot bigger gap to make up for in terms of distributing benefits. So the date when all of this is going to kick in is still to be decided in Washington. We may get some more word on that in the next couple of days. And the dates in other states, they're saying somewhere between mid-September, late October. Some states have said, quote, weeks away. According to Forbes magazine, most states that have applied have said it'll probably be at least mid-September. So just as a heads up that it's probably not going to be kicking in immediately. And there is worry about how many people will qualify. In states like Texas, where there is a requirement that you have to be receiving $100 in benefits already in order to get this added benefit. In Washington, that's mostly not an issue because our minimum benefit is more than $100. But there are some people who are going to fall below the 100 because they have other income to report. So part of that income gets subtracted from their weekly benefit amount. So a few people would not qualify. However, in Texas, where there are a lot of people who are getting less than $100, there's already 350,000 people that are not going to qualify for the $300 benefit under the lost wages assistance. So the important thing here to remember is it will take a while to crank up. It may not last very long. The funding is highly uncertain because of the source, FEMA's Disaster Relief Fund. The second thing I wanted to mention is just briefly we received a lot of comments and really concerns about the stricter questions that have been showing up on the weekly claims for PUA. Those are due to a kind of crackdown on the part of the feds to make sure that people's, from their standpoint, that claimants' reasons for collecting PUA are still related to COVID, and they have to be directly related. So a lot of the questions are very, very piercing about exactly why, for example, your place of business or your employer's closed. In some cases, that may be due to a contraction in business that would not be considered directly a COVID-related reason. So what happens in those cases is if you, on the questionnaire, you don't answer a question in a way that they interpret as qualifying you for PUA, you may be switched back to regular UI, unemployment insurance, regular benefits. And that's just because there may be less of a connection in your claim to actual directly COVID reasons for being unemployed. What we've suggested about people who have expressed concern about the questionnaire is try to see what the intent of the question is, not to interpret it too literally. Because if you feel that you genuinely should qualify because you have a COVID-connected reason, then you should try to see the questionnaire in that light and not try to look for ways to exclude yourself from benefits if possible. But be careful, of course, because you don't want to get an overpayment. It is a tricky line to walk. Next, I wanted to talk about the new guidance that has appeared from the Department of Labor, because what is on everybody's minds right now is the opening of the schools. There are 3 scenarios that they've laid out for what kind of what will qualify you for continuing to receive PUA, unemployment assistance, in light of your children's school situation. So they have a lot of concerns about program integrity and ensuring it, and prevention and detection of improper payments and fraud, et cetera. As you know, if you are unavailable to work because a child or other person in the household for which you have primary caregiving responsibility is unable to attend school or another facility that is closed as a direct result of COVID-19 public health emergency. And that school is required in order for the individual to work, then you can qualify for PUA. But what happens when various situations, and there's a mixture of different scenarios that are arising out there in school reopenings. So the first scenario that they mention is if the school goes completely online as a direct result of COVID-19, that's considered a closure. So if they're only providing online instruction, you don't have any choice, then it is considered that the school is not open for students to be physically present at the school, and they're closed, then PUA eligibility is really not an issue. The second scenario is if the school system is operating in a hybrid situation, again, as a direct result of the COVID-19 public health emergency, where students are attending school online some days and in person other days. Then the school is providing a combination of online and in person. It is not open for certain students to be physically present at the school on those certain days when receiving online instructions, and therefore is considered closed. An individual who is permitted to work from home but must provide such ongoing and constant attention to the student for whom he or she is the primary caregiver, such that working from home is not possible, may be considered unable or unavailable to work. So they still could qualify for PUA, but not for regular benefits. And then the third scenario is the school system provides students and families the option to stay at home or to attend online classes remotely. In that case, it is considered that the school is not closed. So if the individual is the primary caregiver, chooses to have the students participate in remote learning in this option situation, instead of in-person instruction, then you do not meet the provisions of under the CARES Act to receive PUA. So you would be ineligible. So there should be a lot of churn going out there when people are trying to figure out where they fit into these different scenarios. But it is tighter requirements for PUA. And then also to receive the lost wages assistance, you need to have a COVID related reason. So people under PUC, people would receive the $600 extra even if they were getting regular benefits. They didn't have to have a COVID related reason in that case. Now, however, those people would not qualify unless they had a COVID related reason. So again, one of those, there's going to be a lot of back and forth trying to decide where people fit in that picture. In terms of what the Unemployment Law Project has been focusing on, we've been trying to get people to look at the amount of benefits that they've been receiving under PUA, because we believe that many claimants have been shortchanged. Now, not just in Washington State, but in our state, it's particularly clear to us because the amount of benefits that have been, the average amount that people have been receiving is extremely low compared to what you would have received if you were getting regular benefits. Now, admittedly, people who are receiving PUA have a lot of different conditions. Many of them would only qualify for the minimum benefit. For example, you might be getting PUA because you didn't have enough work hours to qualify for regular benefits. In that case, you're probably going to get the minimum, which is $235 a week. However, many other people who are self-employed or gig workers were receiving greater net income than would match up with such a minimum level of benefit. What happened in a lot of these cases is people submitted their documentation, but for some reason ESD considered it to be inadequate to demonstrate their net income. One way this could happen is if you submitted 1099s, which showed your income as a self-employed person for the year, but you did not submit evidence of your expenses to show what your net income would be. Obviously, it would be less. So if there was a question mark there that you had submitted your gross income as a self-employed person rather than your net income, then you would have automatically received the minimum benefit, even if you should have qualified for more. So it's not too late to fix that. So we have been trying to advise people to be sure and check on your account to make sure that that they have adequate documentation of your self-employed income in order to match you up with the right weekly benefit amount. Because in many cases, this could be several $100s more than what you are receiving. The maximum benefit is still $844. Many people are only receiving $235. If you were making $50,000, $60,000, $70,000, it's likely that you would be receiving more than the minimum benefit. So what ESD has advised us to recommend to people is that they submit adequate documentation of your 2019 net income. That would be a 1040 return in most cases. That would be the best evidence to show what your net income was. And in those cases, ESD is actually required to recalculate your weekly benefit amount based on the new documentation. And you can do that at any point when you're receiving benefits if you think there's been an error. But it's specifically written in the law that they need to recalculate it. And you have until December 27th to do this. And it would be retroactive too, to whenever the effective date of your claim was. But we would recommend that you do it as soon as possible because, as you know, things are not happening overnight very quickly, lightning fast at the Employment Security Department. So the less delay you have in getting this documentation to them, probably, the better. And finally, we wanted to mention what another issue that the Unemployment Law Project has been working on, and that is our concern about people who have filed appeals. They've been denied benefits. They, let's say it's a PUA claim, because if you're denied benefits under regular benefits, you may still go on to file for PUA and you may qualify. But let's say you're denied PUA benefits and you get a denial. It says you can appeal within 30 days. Many people have done this starting back in April. But many of those appeals have somehow gotten stranded and stuck at ESD. ESD has told us that they've gotten between March 1st and July 30th. April, May, March, April, May. So 4 months. March, April, May, June. So 5 months. They've received 81,000 appeals, but only about 13,000 of those actually went to the Office of Administrative Hearing in order to have a hearing scheduled. Now, ESD has an in-house process where if you appeal a determination, they will try to figure out if they can redetermine it in-house, which is usually helpful because that would be faster in many instances than having it go to the Office of Administrative Hearings, get a hearing scheduled, hear it before a judge, wait for a decision, and so on. Normally that would be faster, but it's been taking weeks and weeks. So as a result, it's not speeded things up. And a lot of appeals are not landing at the Office of Administrative Hearings. They have not received very many. Now we hear that they're starting to receive more, but we still estimate that there are somewhere in the vicinity of 30,000 appeals that have not arrived at the Office of Administrative Hearings. No hearing has been scheduled. No judge is scheduled to listen to the person's appeal. So this is a serious problem. We're writing to the governor about it. We're trying to get more concerned. We've had some stories in the press as well. And it's a major concern. If you have an appeal that you feel has gone weeks or months without being heard, I request that you get in touch with me at the Unemployment Law Project. I'd like to hear from you because we can use more evidence of what we suspect is happening, but we don't have direct proof because the Employment Security Department has given us some numbers, but they haven't exactly confirmed that the missing hearings are still at ESD, but we don't know where else they could be. They aren't at OAH. So that's where we are with that issue. We're hoping to get some more evidence of it, but we're definitely sure it's happening. And so I think, John, you might have some comments on what's happening with the lawsuit.
First of all, about the hearing issue. This has been a big problem. Every day we talk to people who have requested hearings as long ago as March and April who are still waiting for hearings. So if you have this issue, call the governor's office, call your state senator, your state representatives. But even if you're not personally affected by this and you're concerned for others, I would call the governor's office and email the governor's office on this issue, because we really need to move these cases into either being resolved without a hearing or having a hearing set up. I spoke to a man, who had his hearing a few days ago, and he had requested his hearing the first week of April. I believe he finally got his hearing, and he had said that a few days before the hearing, he had a call from Employment Security wanting to talk about the matter. And of course, he ignored the calls. He didn't trust it. He went ahead, he had his hearing, and he won. So they are making these efforts to resolve, but why couldn't they have done that months ago? So it is an important issue. So please call and write to the governor about this issue on behalf of yourself and on behalf of others. The writ of mandamus at the Washington State Supreme Court which was originally filed June 5th, is moving ahead. The court has retained jurisdiction of it. It could have been dismissed. The Attorney General's office has been trying to get it dismissed for various reasons. They said that the issues have been resolved, which is not correct. They've said also that there's no standing for the plaintiffs, including the Unemployment Law Project. So Bob Ferguson and his team are doing all they can to get this issue off the table. And it is true that many issues in many cases are being resolved. And it's very fortunate that we did have this filed in early June, because I think that led to a quicker resolution for many cases, but the problems are still current. The Unemployment Law Project still receives hundreds and hundreds of calls each week, just like we were getting calls back in April and May and June and July. So the problems are still there, and they put out Operation 100%, which is great public relations tool, but that only was 100% of a certain percent of people who had never received any benefit at all between certain dates. So that was not counting people who received some benefits and were cut off, or people who were improperly denied benefits, who even after providing information, who have not been given their benefits or given a hearing. So there are still thousands and thousands of claims. My personal estimate is somewhere between 50 and 100,000 claims have issues that need to be resolved. So there's some progress on the hearing front. But as the RIC goes forward, we're still collecting declarations. If you or someone you know wants to make a statement, to be interviewed about what you have been going through for the last few months, you are welcome to do that. We have about 700 people signed up for declarations. So the briefing is going ahead, and it's unclear when the oral argument will be, but it will be this fall. And we're, of course, pushing for it to be as soon as possible. The motion of it accelerated was denied. I don't know if that's political or not. Maybe they'll hear it on November 5th after the election. That's one theory, but we'll see. And it's something that's being covered by local media. The Seattle Times, King 5 News, and Cairo News have been very interested in these issues. So that's another source, another method if you want to address these issues, like, for example, writing letters to the editor of the Times would be very good to keep this issue arise, because just like the Trump administration is trying to pretend COVID is somehow over, I think Employment Security Department is trying to pretend that this issue has already been resolved with Operation 100%.
Thanks, John.
Great, thank you both. Shall we move on to questions?
Yes.
Excellent. Regarding the lost wage assistance program, Anne, that you had mentioned, we have some information from a participant who says the Department of Labor guidance has Q&A on their website, and there's a link, but I'm having some trouble opening it, so I'm going to keep working on getting that attachment. But he has provided the Q&A, which says PUA allows an otherwise eligible individual to be covered if he or she is unemployed, partially unemployed, or unavailable because of a listed COVID-19 reason. For lost wages assistance, must the individual's job separation be directly related to COVID-19? The DOL answer to that question is no. The most recent job separation does not need to be directly related to COVID-19. At the time of self-certification for the program, the individual must be unemployed or partially unemployed due to disruptions caused by COVID-19. Our participant is wondering if ESD is aware of this DOL position.
So I'm looking at this question. I'm not exactly clear when when this Department of Labor guidance was written, but there has been a lot of confusion about what separations and when would qualify, would interfere or not interfere with your eligibility for PUA. When PUA was set up back in March, it was made clear that if you had a job separation before COVID struck, in which you, for example, you didn't have good cause for quitting, or you had a firing for misconduct, even if you had a fraud finding, you could still qualify for PUA. So that was true back then. Now, what about separations that occurred during COVID? I have not gotten clarification on the status of those, and it's very confusing. So I'm not really sure about this Department of Labor guidance, what period of time it's referring to, but I do know that since just before the lost wages assistance plan was being discussed, they did adopt more stringent rules about what could qualify as a COVID-related reason. So I would say in general, it's just unfortunately something you're going to have to ask the phone operators at the Employment Security Department to clarify. If you can find one who understands, this is kind of a complicated issue. Tier 2 or Tier 3, I would say. John, do you have any comments on that?
Well, just, this has been a headache for months, this question of whether you're unemployed due to a job separation related to COVID or currently unemployed due to a COVID-related reason. For example, if you had the misfortune of losing your job prior to March, but then your business closed down anyway, or your field is closed down anyway, I would say there is a COVID-related reason for you being unemployed, in May, June, July, August, September. But again, some might argue that it was not a COVID-related job separation. So we have never been in this experience before. It's been frustrating over the last months to have so many new questions that really don't have clear answers with contradictory rules and a lot of conflicting information from employment security and other sources. In general, when you're claiming, the best advice is to just answer those questions in the best way possible. If you have specific questions about your personal situation, you can always contact the Unemployment Law Project for advice about your situation. There are tough consultations to give because of the language being closed, but I think a general rule of answering questions correctly and in good faith is a good practice.
Excellent. Thank you, John. And along those lines, one of the new PUA weekly claim questions is, quote, "We've received information that you may have an unemployment claim in another state or with the U.S. Railroad Retirement Board. Have you applied for or received unemployment benefits from another state or the U.S. Railroad Board in the last 12 months? The person who's received this question is a self-employed construction contractor. Doesn't know why they're being asked this question, that they've received information seems to be in error or sort of a tripped up question. Do we have any guidance on
Many.
this question?
So we're getting many calls. I've talked to many people in the last weeks about this. I don't know if it's just a glitch. Initially, I thought it was with the railroad issue, it's railroad or maybe some other kind of pension. I thought that was the reason, that maybe there was something triggering these inquiries about maybe you had a 401k with your social security number, something like that. I was theorizing that. But after talking to many people in the last few weeks, I'm convinced that this is a totally random error. Mm-hmm. Now, when dealing with employment security, think of it as a huge machine. That's not a person who's looking at your file. If you imagine what the unemployment program was like in the 1930s, you can picture file folders and drawers and offices and caseworkers and individual offices around the country. Well, now it's a big computer machine. So if the computer machine sends you a letter wanting an answer, the best thing you can do is just answer that. Try not to be too sarcastic, as I would be. and just say, no, I am not. I was never a railroad worker. I don't have a pension. I don't have enough, just sort of lay it out and get it in as soon as possible, because a little thing like that in the computer, that you were sent a questionnaire and didn't respond, could lead to a denial of benefits and overpayments. So it's better to kind of deal with it as quickly as possible, and don't assume. I mean, this has been advice we received for years. We've been giving people for years, because sometimes people would get like a random overpayment notice, and they know on the surface it's wrong, like it's just an error, and they ignore it, and then it goes to collections, and then they try to get a hearing, and then they are denied their hearing because they filed their appeal too late, and then they're stuck with a debt that is completely unfair, and because the machine is very unforgiving. So it's best to read these letters, no matter how absurd they are, and just answer them in a timely manner.
Excellent. Thank you, John. We have a participant who's currently working remotely because they're 65 years old and thus high risk. If their employer tells them they have to return to the workplace, but they choose not to, what are their options regarding ESD and unemployment, and can they claim an age discrimination?
So if you're requested to return to your job, you're generally required to go back to the job, but you're not required to accept work that is not suitable. So what is suitable work? It's work in line with your qualifications, your experience, your prior jobs, but you do not have to work in a place that is unsafe. That would not be suitable work. How do you demonstrate that it's unsafe? The Department of Labor and the Occupational Safety and Health Administration have guidelines for exactly what employers are supposed to be doing to assure that their employees are relatively safe at work, and it includes very specific provisions such as mask wearing, social distancing, training in sterilization. There's about 5 or 6 provisions that employers are supposed to follow, and you can find them at the LNI site, Labor and Industries. But you can't give your employer a generalized fear of COVID in general. Now, if you have a specific high risk and medical documentation, that would give you a good case for saying that you can't return. And still, if you're receiving PUA, one of the reasons why you can qualify is if you have a COVID-related reason for being unable to work, not just for being unavailable to work, that you cannot go back to your workplace specifically because of a specific safety issue. So you should be able to continue qualifying under those grounds.
I would like to add a few points. Just that sort of generalized fear of COVID may actually, for some people, be severe anxiety, which is a medical issue. So each case is different, and we've received this question from people of all ages, and some people with family members with compromised immune systems or other health issues, or people concerned. In general, like I said, unsuitable work is something you don't have to accept. Even prior to COVID, that was basic unemployment rules for many reasons. And something can be unsuitable for reasons of pay or geography or other issues. But it may be good, depending on the profession, to see if there's a possibility of an accommodation. Can the employer, there are so many jobs, there's thousands and thousands of jobs and different kinds of jobs. There are some jobs that can be accommodated with telecommuting, depending on what it is, and then other jobs that would be absolutely impossible. Even a job like being a nurse, I had, early on in the pandemic, I was talking to a nurse, and when I picture nurses, I picture a nurse in a hospital working directly with patients, and it turned out that this particular nurse did consulting, was consulting and really was able to telecommute, and that actually worked out well for her. In that situation, she could do appointments by phone and and actually do her work. So each job is different. Each job has its own, you know, requirements and necessary. If the, it's good to have some documentation of what you provide, either your request for accommodation and doctor's notes, you know, advising you not to accept those working conditions, even if they are safe. So this is one of the questions that came up early in the pandemic. Well, I'm a necessary worker. Does it mean after work? Well, your job might be there. It might be considered necessary. However, it might be unsafe for you. So this person can also get individual advice from the Unemployment Law Project.
Great, thank you, John. Also, regarding the age discrimination issue, I put in our chat box the link to the Washington Employment Lawyers Association, WELA. They are attorneys who deal with issues such as age discrimination. They represent employees. You can check out their link and find their member directory there to maybe be able to get more assistance that way. Okay, we have a participant who says she is being retaliated against in a job that she's held for 9 years. She is mentally and physically ill from the treatment she's been receiving. She desperately wants to quit because it feels extremely hard to stay, but she's unsure of whether she should quit and how that would impact her unemployment. She also has a green card, and she's curious as to what are her options. Is it significantly better if she asks to be laid off? Does that also impact her chances for receiving unemployment?
Well, I'll take this one. Asking to be laid off is interpreted by unemployment to be a quit. So unless the employer really agrees with that and agrees not to say that you asked for it. So because once the cat's out of the bag, as they say, then employment security will call it a quit, and then it has to fit into one of the categories, whether it be medical reasons or illegal activities. So it's hard to tell because I know all the time there are private agreements that go on all the time that an employer may agree to lay someone off, and ESD knows no better, and the person gets benefits. But employers generally want to fight unemployment claims because it impacts their tax rating, which is a terrible thing about the system, but that's how it is. So this person, if the ill treatment rises to a level of illegal activities, which is discrimination based on age, race, religion, gender, for example, and other categories, that may be good cause for quitting due to illegal activities, but it requires the person exhaust all remedies prior to quitting. You know, going higher up in the company, getting documentation, allowing the employer to fix the situation, which is often unlikely to happen. But you're saying that it's unlikely to happen carries little weight with employment security. It may be easier to go a medical route here and to get some doctor's notes about the medical conditions, and then that as well asking for accommodation, and if accommodation is possible. But having doctor's notes, especially a doctor's note in the end advising you to quit, that it's medically necessary for you to quit, and that document, and that no accommodation was allowed, would be the strongest claim in a situation like this. But these are very difficult cases. Employers fight them because employers always want to claim they've done nothing wrong. I've never seen an employer, in many years of doing unemployment, I've never seen employers admit that they did things wrong. But it's good to get that medical documentation and protect yourself, and also contact the Unemployment Law Project for more specific advice. This is a very general advice about what a person in this type of situation should do, but each case is unique, and that this is general advice. So in your individual case, you should get an individual consultation.
Thanks, John. I did provide the participant my email address, so hopefully they reach out to me directly. On another similarly related question, we have Oh, actually, I'm sorry, unrelated, but also someone who should probably contact us directly is a participant's son was stuck in the potential fraud issue, and their account was locked out and they had not been able to file weekly claims or receive benefits since May. He had spent countless hours on the phone trying to get a hold of someone at ESD, finally received an email, and they requested that he upload his driver's license and social security card. Once he had done that, he had received an error message. So now he's stuck again. Do we have any advice or information that we can provide? I did provide the participant my work email address to give some additional context, but is there anything we can share here about what they can do?
Well, some people, and I say some, not all, many people have gotten help from their state senator and state representatives. So the Washington legislature has many districts around the state. You have one senator and two representatives. You can call and email all three of them because you don't know which one might have a more active staff or be more responsive. Also, I've heard that Senator Patty Murray's office and Representative Jaya Paul's office has been helpful, and Kim Schreier, who are federal representatives who normally don't deal with state issues, but they've kind of jumped into the fray. So trying these angles, because what's frustrating about this for Unemployment Law Project is that if this person were denied and had a hearing coming, we could represent them in a hearing. But when a person's claim is just stuck, if you request a hearing, you get a message back saying you haven't been denied yet, even though you have been denied. So going that legislative route can be very, very helpful.
Great, thank you. And I did drop the District Finder website into our chat box. So if you input your address, you'll be able to know who your legislators are in Washington State. We have a question from a substitute teacher. She's on unemployment now because of COVID. She's on week 22 out of the 26. She will apply for PEUC. If she is awarded PEUC, her understanding is that her unemployment will extend for another 13 weeks. Is she expected or required to then apply for her old job or another job? She asked the substitute coordinator what happens now for substitutes since schools are starting online, and it was suggested that this participant reapply for unemployment. Does she wait until next March to do that, since that's when her benefit year is expired, or does she do that now? Any advice?
So the job search requirement, which is normally a core requirement of receiving unemployment benefits, is still suspended until September 1st. So there's no requirement to look for a job right now. And in fact, the wording I've seen is that requirement is suspended, quote, until further notice. Now that doesn't mean it won't come back into effect September 1, but in the past what's happened is as we get closer to the end of the month, the legislature starts feeling that they need to extend it farther. So it may be extended to October or November, or even the end of the year. We don't know. Do be prepared though, from whatever starting whatever date we have most currently, which is September 1, to be ready to look for any old job, whether or not you think you're going to find one. However, you're not required to look for a job that is not in line, again, is not suitable work. The only time you're required to do that is if there's absolutely nothing available in your field and it's clear there isn't any hope of employment there. Then they do expect that you will expand your job search right now. So you don't have to look for work until September 1. After September 1, it won't hurt to look for work in your field. There should be some openings that you should look for. You really want to convey the message to Employment Security Department that you want to work, that you're not just collecting benefits. That's not a message that they are going to receive very in a friendly way. They want you to be under normal circumstances looking for work. Under all circumstances, you must be available to work, except those cases where you have a medical issue or a childcare issue during COVID. You have to be available for work. If you're offered a job that is suitable and the employer can show it's suitable, then you're expected to take the job and not continue on benefits. So you need to think, it's important to think in those terms, not what is the maximum length of time you can collect benefits. You need to show that you're willing to work and that you're available.
We've been getting a lot of calls about this job search requirement, and so now it's the end of August, and as of what I've heard in the last few hours, there hasn't been any action on extending this. So we can assume that they won't extend the suspension of the job search requirement. But job search requirement's very simple. It doesn't mean there has to be a job there, or it doesn't mean you have to get the job. It means you have to do a serious application, either filling out an application or sending a resume or whatever is customary in your field and keeping a record of that. Now, over the years, this issue's come up, do I have to apply for a specific job? And the answer is no, meaning, let's say you work in the food industry, you work for restaurants, and you're doing your 3, 4 or more job searches a week, and you know this one particular restaurant down the street is the horrible place to work. You know, it's just nothing good about working there. There's no requirement that you absolutely apply in that one place, so that if the person who asked this question had some particular reason why the school district they worked for, there were issues or problems, if there's other districts to apply for or other jobs that you're qualified for, that's fine. There's not a requirement to absolutely look at a particular place as long as you meet that job search requirement.
But one word of warning though, if you say, we have run into claimants many times who've looked for work without any success in their own field, and they finally given up and said, okay, I'm just going to take whatever I can get, and they take, say, a server job or a cleaning job. What happens if you take that job and you find that you need to quit it, or for some other reason you have a job separation? The Employment Security Department technically looks at you as being in that occupation now. You have suddenly transformed into a person who is a server or a cleaner instead of, say, a substitute teacher. So that's something to keep in mind. It can be a real pitfall. So if you try to look for work in your field, that as long as you can, if there isn't any work, that's when you may have to switch to looking for another field.
Great, thank you. We have a participant who is currently receiving unemployment insurance benefits. They are 69, they're employed in a high-risk healthcare, and they're not working due to their high-risk position. They're planning on continuing to go back to their position once it is safe to do so. Their question is, should they sign up for the PUA today and file last week's claim as well?
Last week's, well, you can, since the COVID crisis began, normally you can't backdate your claim. It's difficult to backdate a claim. But with COVID, people have been able to backdate to the time that they became eligible, because many people couldn't get through. There were a lot of reasons why they couldn't file a claim in a timely way. So the kind of backdating restrictions have been a little bit suspended. But in this case, the person could try to get benefits back to whenever they became eligible. It shouldn't, as long as it was within the COVID time span.
Great. I would also like to add that it appears they are currently receiving UI, unemployment insurance. So you are only eligible to receive either UI or PUA. You cannot receive both. So I am going to drop my email for this participant. If they have further questions, they can reach out to me directly. We have a participant whose appeal was approved. She won her appeal, and so she restarted her claim for February 2nd, 2020, back the date that it was approved. Was this the correct thing to do? Or did she just accidentally restart her claim? She's very confused based on the ESD website. What advice can we give to her?
I guess I'd have to know the circumstances, what kind of appeal was involved.
Well, because sometimes the appeals are very specific to a time frame, and an appeal could be often about a job separation, it could be about an overpayment, or it could be about being able to work, or a dozen other issues. But sometimes the appeal has a certain time frame. There is rules on late filing or backdating a claim. So, for example, if the person didn't claim for certain weeks in the past and needed to do that, if the ESD feels that's a good enough reason, or if they, or if ESD doesn't feel it's a good reason, the person can appeal it and get a hearing on that issue. I know it's hard to tell somebody who's just had a hearing and went through that, Victor, to even think about doing another hearing, but that's a possibility there. Again, these are very, very specific situations. It's hard to give a general answer to that, but in terms of opening, if you won the hearing and there's a finding in your favor, that should prevail, and it should not be a problem to open up your claim or reopen.
Great, thank you. We have a participant who was hired back from their employer, but only on a part-time basis. Do they still have to do the job search after August?
Yes, my understanding is if you're getting partial unemployment, and you have to answer those questions about being able and available and searching for work, and be able to report any income accurately that you earned in the particular week. So this has been a problem for many people because it would probably make more sense to report income when it's received rather than when it's earned. But the ESD rule is pretty clear to report the income when it is earned in that week. Yes, and to keep up the job search. With online applications and emailing resumes, even if you're busy with family and part-time work, it can be a strain, but if you organize it, you can do it. And again, it's not about getting the job, it's about making the applications for serious jobs. And it may lead to, ironically, it may lead to you getting actually a better job or full-time job. So there are upsides to it, even though it does seem like a burden, but it's better to be safe than sorry, because the unemployment office will try to take money back for any excuse they can find. And one of them is not having a proper job search.
Thanks, John. Along those lines, we do have an overpayment question. Looks like we have a participant who was let go from their employer due to a lack of business from full-time primary income. They have a side business that brings in less than $10,000 a year. They qualified for UI with ESD for $235 per week. They've recently informed ESD that they have medical reasons for not working. And the result from that notification was that ESD has sent them an overpayment notice of $230. The participant has now had surgery and is unable to work, but they are scared to submit anything to ESD for fear of having to repay more. What advice can we give?
Again, a very specific question. I would urge you to contact us. Some people choose to just pay back an overpayment and be done with it, to not stir the pot. That may or may not work for some people. Otherwise they can request the hearing. Again, this sounds like something probably better for individual advice. Yeah. In general, even when the job search was suspended, you have to be able to work. And this gets very tricky because many people have some sort of limitations, physically, mentally, education-wise, and you have to be able and available for suitable work, even if you didn't have to do the job search. So unemployment's not a disability program, and yet it's gotten so complicated due to COVID and having COVID-related reasons for not being able to work, having COVID, or taking care of a family member. So it's gotten very difficult to parse out, in terms of an individual case. But in general, you have to be able and available to do suitable work, even if that is telecommuting or even, having accommodations in place, because every day millions of people with all kinds of disabilities do work with proper accommodations. So I think this person should contact us individually.
I want to make one note about job search. I'm just looking at the ESD site right now, and today, August 31st, the word on the site is looking for work is optional. This change started March 8th, 2020, and will continue until further notice. So my suggestion is look at it tomorrow. If there is a note on there tomorrow saying you have to look for work starting today, then you need to look for work. But it may have gotten extended without our kind of realizing it. It's the first time they've said until further notice.
Wow.
Oh, boy. So this is typical because I was expecting some sort of word one way or the other end of August. And I know there has to be some sort of approval on this, but it's frustrating because they've known about this for a long time, and it puts people in awkward position. But again, looking for work, sending out a few resumes, filling out some online applications should not take too long, and like I said, it may lead to a much better job someday.
Great, thank you. We have one more question in our Q&A box. We have a participant who's worked as a paralegal for 3 years. Her employer was extremely unprofessional, treated his clients poorly, was dishonest, lied to his employees, often talked about inappropriate HR-related matters with other workers in front of the whole office. The participant had suffered 2 panic attacks after the employer had tried to withhold pay. Our participant quit their job and would like to apply for unemployment. The question is, do they need to file a claim with L&I before they file for unemployment?
Answer is no. There's no requirement. But one thing to look out, some people file for both, but you can only receive one or the other at the same time. So, for example, if you applied for L&I and got it, then don't claim for the unemployment or withdraw or cancel it. If you get unemployment, some people have an L&I claim pending, and then they get unemployment, and then they get a retroactive of workers' comp. So be ready to pay unemployment back. So it's good to be careful about that, but apply for both.
Great, thank you. Okay, we have a question from a participant who says there's been a change from a few weeks ago in what ESD is asking for regarding income. And my guess is it's related to PUA. Now, our participant says now ESD is asking for gross earnings per week versus net. Do we have any information related to that?
So this has been a point of confusion from the beginning because there's 2 categories here. If you are a regular employee receiving salary or wages, you are supposed to report gross earnings. That's the term used for salary or wages. If you are self-employed, however, you are supposed to report net income. So it depends on which of those categories you fall into. And she says receiving PUA, but you could be receiving PUA as a self-employed person or somebody without enough work history as well. So it depends whether it's salary or self-employed.
Thank you. Self-employed, correct.
Okay, that would be net income.
Great.
It's very confusing, I agree.
It is indeed. That is all the questions we have, and we are running up against our time, coming up on 1 p.m. Would like to thank everyone for joining us this week, and just a reminder that next week is Labor Day, so we will be off, and we look forward to seeing you back here in 2 weeks. Thanks for your questions. Reach out to our organization in the meantime, and we look forward to serving you in any way possible. Thank you.
Thank you.